If you are involved in any sort of legal proceeding, then it's important that you understand the need to give notice to all the parties who have an interest in the legal proceeding, whether it's an eviction, a lawsuit, you're probating an estate, whatever it may be. Courts routinely refuse to hear matters because the judge believes that notice was not properly given to all the parties of interest. And opposing counsels will also dispute whether notice was properly given. So a few things to keep in mind. There are so many ways of giving notice, and they vary from court to court and from proceeding to proceeding, that I couldn't cover them all here. So I could just make some general points. First of all, before you do anything, before you file a lawsuit or petition to probate an estate or an eviction, read the procedural laws for giving notice and make sure you follow those laws to the letter. Now, another point, if you are unsure whether somebody should be given notice, it's usually best to send them notice just to be on the safe side, so that the court can't throw your hearing out or refuse to hear your case because the judge may deem it necessary to give this other person notice. I've had instances where I give notice to everybody conceivable, and the court will still say, well, we want more notice given and a certain notice given to a certain person. All right? So err on the side of caution and send more notice than may be necessary if you're unsure whether somebody should be notified or not. If you're required to publish a notice, make sure that you follow the requirements to the letter. So either the court will tell you exactly what needs to be published, where, and on what date or by what date, or you'll need to follow statutory law, which will tell you how to publish and when and exactly what to say. So know whether you need to follow the court's orders on a legal notice publication or statutory law, and make sure you get it right. I once had a condominium foreclosure, in the publication, which the statutory law told me how to publish it, it cost almost $7,000 to do the publication. And if I got it wrong, the opposing side's attorney would have certainly found it out, and I would have had to republish. So publishing is expensive, and notice is expensive, just generally speaking, and delays in legal proceedings are expensive. So make sure you get everything right the first time, read the laws, double check, and if you have any question whether somebody has an interest in a legal proceeding, it's usually best to send that person notice, like I said, rather than having your case rejected by the court.